Hi everyone, James Manson here, constitutional lawyer. We spoke on Tuesday evening, I think last, when I reported to you all that my organization had filed a notice of application in the prorogation case. I'm just here to give you guys a quick update about what's been going on the last few days and where we're going next week. The application that we filed on Tuesday was accepted by the court on Wednesday, so that starts the ball rolling. Then what happened was we were contacted by the federal court registry staff, and they advised us that because in our application we are asking for an expedited hearing, we're asking for the court to hear the matter, much more quickly than normal, that there were two options on the table. One, we would have to approach the responding parties, in this case the Attorney General of Canada. They have offices across the country, and get their consent from the federal government, really the Crown, as we say, get their consent to an expedited hearing. And if there was no consent coming, then we would need to bring a motion in court to get a ruling from a judge or another judicial officer called an associate judge. These are both people who exercise judicial functions in the court, and they can grant things like an expedited order, expedited hearing, things like that. So anyway, that if we could either get consent or we would have to bring a motion. That was on Wednesday, sometime during the day. And so naturally, we reached out to the Department of Justice in Canada for their consent. At that point, we didn't yet know who we were dealing with because the matter had just been started, and it takes time for the bureaucracy and the departments in the DOJ to assign counsel to the matter, and that's normal. So we weren't really expecting to get consent on Wednesday, so we prepared motion materials for the motion. And while we were doing that, and that took us into yesterday, into Thursday, there's a series of documents that need to be prepared, and including like an argument document. It's called a written representation. And I wonder if I've got it around here. No, I don't. But anyway, there's a document called written representations, which sets out the argument that we were going to be arguing to suggest that the case is urgent. It cries out for an urgent hearing. And anyway, while we were doing that, we heard from the court. The federal court got back to us again and said that a judge wanted to have a case conference with the parties to discuss the case. And that happened today. So that's quite unusual. It's not every day that the court will, of its own accord, ask the parties to come to a case conference. Usually what you have to do is you have to ask the court if it will agree to having a case conference. But this happened the other way around. So we were encouraged by that, in the sense that I think it's clear that the court understands the gravity of the situation and that they agree that this is a case of national interest. So anyway, the case conference today happened earlier today, and there were representatives of the Crown. There were lawyers there from the Crown. I was there, and some of my team were there as well. And there was also Chief Justice of the Federal Court was presiding, as well as an associate judge of the Federal Court as well. And they were both there for the court. So there was a good discussion about timelines and whether this case is truly urgent. Again, I was encouraged from the call that the court was seemingly to be amenable to proceeding on an expedited basis. There was, early on in the call, there was talk about a compressed timetable leading to a hearing, fairly soon. The Crown's counsel, the lawyers from the Department of Justice, they haven't yet been able to take instructions from the government decision makers. So they haven't yet been able to agree to consent expedited case. So they were not in a position to agree with the suggestion of an expedited timetable. And furthermore, at least in these circumstances anyway, the lawyers for the Crown said that they would have to respond to the motion materials that we had prepared. You see, what had happened was, last night we sent in the materials that we had prepared for the expedited motion, hearing motion, and we wanted the court to at least have them. Today's conference was not a motion. It was not where we were going to decide the issue, but it's usually a good idea so that the judge understands the materials that he or she may need to deal with later on if the whole thing comes to an actual head and he has to make a decision, or she has to make a decision. Anyway, the Crown's lawyers basically said that they needed time to respond to the motion that we have now filed. So they asked until Thursday of next week at the outside limit. They'll try to get their response in quicker, and Thursday is the deadline. My point of view on the call was that was perhaps quite a lengthy time. We were able to get our materials in a couple of days, and it wasn't clear to me why, the balance of today plus 4 more days was necessary for a response on a fairly, preliminary point. But nonetheless, the court, of course, wants to be fair to all the parties, and I agree with that. And we want to give everybody a chance to have their say, and I agree with that 100%. So the Crown now then has up until Thursday, I think it's noon, to submit a response to our motion to get an urgent hearing. Now, this all may be short-circuited because if the Crown is able to get instructions from the government on Monday, then they are going to reach out to us. If the Crown has favorable instructions from the government to agree to an expedited timetable, then we will reconvene on Monday afternoon to set that timetable, to figure out when is the date of the hearing and how long people need for submission of their materials and preparation of all of our legal briefs and things like that. So we will see basically what happens on Monday. If we hear from the Crown on Monday that they consent to an expedited timetable, then we will, again, be able to have that timetable set down. If we don't agree, then the Crown will have to respond to our motion for a formal order to grant an expedited timetable. And that will happen probably sometime next week, probably towards the end of the week. I guess it would depend on how much time the Crown needs to get its materials in. So that is where things stand right now. Naturally, we were encouraged again by the court. They, in my view, the Chief Justice definitely understood the sensitivity of the case, the urgency of the case, and we will see how the court ultimately rules on the motion if that has to happen. Naturally, it's possible that the Chief Justice is persuaded by the responding party, the Crown, that the matter is not urgent and it doesn't need to be heard on an expedited basis. If that is in fact their position, naturally we believe it is. So this is why we have courts and judges to decide these types of issues. So that is where we are right now. And we will, of course, on our side, keep working on the main brief for the main argument whenever that happens to be. So thanks again, everybody, for listening. I hope, again, this has been of some value, and I will continue to provide updates as I can as events progress. Thanks. Have a good weekend.